And George is going to be watching that too. So if I miss one, he'll remind me. So please, if you have any questions, pop those into the chat and we will do our best to address them. And if we have time left at the end, we can do additional questions then. So with that said, are we ready to get started, Tim?
Certainly are. I figure out how to move the slides here.
So, of course, you've got two lawyers here, so we have to have the disclaimer. So we'll just leave this up and let you read it or not, but it's up there. All right. I think that's long enough. What do you think?
Okay. I do too. Yeah. So what we're going to do over the next hour or so is try to give you some insight as to, social inflation, what it is, talk a little about nuclear verdicts, but then really kind of break down to an extent sort of the component parts that we see really fueling what's going on. The term itself is not really that new. Coincidentally enough, Warren Buffett, the chairman of Berkshire Hathaway, by the way, Gen Re is a Berkshire Hathaway company, really coined this back in 1977 in one of his early letters to shareholders, and really came up with a definition then that I think serves just as well now. Basically, that social inflation is a broadening definition of by society what's covered by insurance policies. And what we're going to do over the next hour is really talk about the items in these 5 boxes. By the way, this graph comes from a study on social inflation that was done by the Geneva, Switzerland-based Geneva Association, insurance think tank, put out in 2020 what I think is a very comprehensive report on social inflation. If you want to take a look at that, I encourage you to do so. But really, that report in this presentation is going to talk about these 5 boxes. We're going to talk about wage and price inflation. Certainly, we've seen that as consumers and on the first-party side in the industry, but also it's really been a factor in driving up some of these damage awards, healthcare costs being much more expensive than they were previously. Another component is litigation, legal risk, interpretation of, courts of insurance policies in a way that carriers hadn't intended, damage awards, theories like public nuisance recovery theory, things like that have sort of been thrown into the mix. Societal shift. Society in 2023 is certainly much different than it was 20 years ago. Certainly much different than it was prior to the COVID-19 pandemic. We'll talk a little bit about some of those factors. Medical cost inflation, certainly that is a big component of what we're seeing generally with inflation, but we certainly are seeing it as being a component part of these substantial settlements and awards we've seen in recent years. And then finally, emerging risks, the things that, I try to keep up here with at Gen Re. There forever will be emerging toxins, issues that we as a society are going to have to deal with, and in some measure, some parts of society will look to for compensation regardless of whether they were intended to be covered or not. Things that come to mind there obviously are the emerging concern about PFAS, microplastics, and traditional environmental type exposures. Obviously, climate change is a very broad category, but that is certainly one that would fit into that category as well. Okay, so, really to kind of break down these buckets, wage and price inflation has been a big thing. I mean, we've certainly seen that explode really as we came out of the pandemic. But there are other factors at work here too. There's been some suggestion by some that society has in some measure been desensitized to the value of money, confusing billions and billions and billions with millions and trillions. What does that mean as far as calculating these awards? And the other thing that we've seen happen too is what some commentators have called the hollowing out of the middle class. We have in this society a middle class that is shrinking. Some concern that wealth in society is concentrated in urban and coastal areas. You have increasing numbers of people with some sense of economic insecurity. What does that mean as to how they might view a plaintiff in a given case, how they might view corporate defendants, institutions, that type of thing. So, these
and it also goes to your jury. It goes to your jury pool too. Yep. Who is going to be on your jury, and that's obviously going to differ by geographic location. It could be, different things like the time of the year that the trial is. If it's a time where parents are going to have a hard time being on the jury, that's going to have a different impact. We have also seen that with COVID, a lot of jury changes, and it's not clear sort of whether we're going to go back to where we were or not. But certainly all of these issues are ones that not only potentially impact on the parties of a given case, but certainly the jury as well and their perspective going into making these decisions.
Absolutely. So, really too, the other thing too, related to this whole notion of money and what it might mean. The old saw is athletes, entertainers, and the lottery may be in some measure driving some of these awards. You've got something that I never thought I'd see in my lifetime: billionaires actually taking rocket ships up into space. Bezos and Branson, I guess what I'm trying to say. Certainly the amount of earnings generated by actors, Tom Cruise in the most recent Top Gun Maverick. You have athletes signing, contracts upwards of $500 million with much guaranteed money. All of this being thrown into the mix and almost subconsciously a factor into how a jury might evaluate damages and compensate for pain and suffering, non-economic damages. So, one thing, and Laura, by all means, chime in here at any point. So you're hearing a lot in the industry about, what's a nuclear verdict. It's really probably not the best term, but by definition, it's really any award that's greater than $10 million. There's a subcategory called subnuclear between 5 and 10 million. Some of this depends. Oh, go ahead. Yeah. Tim
and I have discussed this. I read a definition that resonates more with me as to what a nuclear verdict is, and that is Kiera Taylor wrote, "A nuclear verdict is the classic disproportionate response. It so far exceeds a reasonable damages amount that only emotional or punitive juror motives can adequately explain it." To me, it's that ratio between actual damages and the award. If you have a situation where you have, $100 million of actual damages, then $100 million verdict would not be a nuclear verdict in my mind. We certainly see big verdicts in some of these big corporate cases and things like that. But in my opinion anyway, nuclear verdicts that term, or I like this aberration verdict, ought to be limited to situations where it really is disproportionate, that sort of by the numbers, they don't make sense, that having some award higher than the actual damages isn't in and of itself a problem. But if that is, 100, 1,000, 10,000 times the actual damages, that's a different situation.
Absolutely. And the thing that, we do want to emphasize here too is that, we are seeing them increase, and a greater proportion of the damage awards are made up of non-economic damages, pain and suffering. That's something of a concern. This next slide is actually from an excellent study that was done by the United States Chamber of Commerce, Institute for Legal Reform, public available. And really, I think the point to take away from that is that there have been certain lines of business that have been hit more heavily than others. Certainly medical liability in recent months, we'll talk a little more about that, has seen its share of these large awards, but also personal auto, commercial trucking has seen a significant number of these nuclear verdicts in recent years. And, not just the nuclear verdicts, but also settlements amounts greater than what we've seen in the past.
And one thing Tim and I were talking about when we were preparing for this, how 30 years ago when I started practicing, a bunch of my colleagues do medical malpractice. And at that time, the defense had essentially an advantage in most cases because doctors rarely is too strong, but you had to have very strong facts for a jury to be willing to find against a doctor, that people wanted their doctors to do the right thing. Now, clearly that has changed since medical malpractice is one of the biggest wedges in that pie chart. So an interesting perspective on, maybe societal's view of the medical service industry and what we are seeing from our in our own lives. And again, it's those jurors that, and what their perspective is and how they, their life experience with these things, what it brings to the table, and to some extent what lawyers are allowed to present in cases, which varies depending on the court, the judge, the state. The laws are different on what information can be made available, and whether, for example, a monetary amount can be requested by the plaintiff. Some states allow that, some don't. All of those things can make a difference in what the result is when the jury comes back with the decision.
Absolutely. So the trend line is, disturbingly going up. One of the things that, that we try to do informally, Laura and I, certainly we do at GenRe, is try to keep up with some of these verdicts. And, I'm not going to go into all these in great detail, but I think the thing that is significant is that we are starting to see now on a national basis these nuclear verdicts pop up in areas that we hadn't seen historically. For example, a $56 million verdict in a horrible industrial accident case in Minnesota. That at the time, I think it still is obviously a record verdict. We have certainly seen a number of these cases in Georgia, where I'm coming to you from. We had the infamous $1.7 billion verdict against Ford for the F-350 rollover cases. But we've also seen them take place, as I say, in other parts of the country. Florida has seen its share of significant nuclear verdicts. But I guess what I would say to you is that they're taking place in areas that we haven't seen them before. And one of the things that we're starting to get a little bit concerned about, more than a little bit concerned about, is that, the jurisdictional distinctions that we once saw, venues that were once conservative, may not be that way as they were in the past. And the other thing I wanted to mention to you before I forget is that some of the Georgia verdicts up here have taken place in rural counties. And to speak to, what Laura was saying a couple minutes ago, certainly they're now taking place in counties and venues that simply would not have been thinkable 15 to 20 years ago. So we're seeing more of these verdicts, and we're seeing them take place in areas that we hadn't seen before. And to pick up on that,
they're getting a lot of press. So even if you're not in one of those locations, that doesn't mean that your jurors won't have heard about it. And it goes to those large numbers not, losing their shock factor. I've certainly seen it in myself. Tim and I have given a couple of different versions of this talk. And over that time, the amount that seemed shocking in one of our first presentations didn't seem so shocking anymore. And that's just been over the last year or so.
Absolutely. Just a quick word or two on medical liability. One of the things that we're seeing in the industry is that we're seeing these large verdicts take place, not only in bad damage cases, but also in venues that we really hadn't seen before. For example, a $97 million verdict for a birth-related injury case in Iowa City, Iowa. Interestingly enough, that has triggered activity on the part of the state legislature there, where they have now implemented a cap on non-economic damages in Iowa on medical malpractice cases going forward. Whether that holds up or not in the future remains to be seen. But these verdicts are creating some interest and action in the various state legislatures. One of the things I did want to mention here, too, the $26 million arbitration award, that is for a case in California. And of that $26 million, $21.5 million was earmarked for future health care. So, again, we're seeing these large verdicts, not only in traditionally high-risk type medical malpractice cases, but others that have facts that weren't on the face of them really all that concerning. So the other thing I would mention to you, too, subset of medical liability, we are starting to see a number of large awards in nursing home long-term care facilities. So, and there's some studies that are taking place talking about this. The Doctors Company, a big medical liability writer, published a study late January talking about that by their calculations, and social inflation is adding somewhere between $2.5 and $3.5 billion to medical malpractice losses. So that study's publicly available. If you have any interest in that, by all means, go ahead and take a look at it. But we're starting to see now in the industry the suggestion, not just a suggestion, but quantifiable data that suggests social inflation is driving up healthcare costs, driving up insurance costs.
Well, it's also potentially impacting on whether doctors get insurance, because not every state requires medical malpractice insurance for their doctors. And if it's not required and it's becoming cost prohibitive, I would suspect that there's going to be a certain percentage of doctors that don't get the insurance. And then that obviously has an impact as well.
Yeah, Laura, I'm really glad you brought that up, because there have been instances historically where that's happened. For those of you on this call that were in the industry in the mid-'80s when I started, there was significant adverse development in general liability lines of business. Some carriers were running combined ratios in excess of 140. There was a question as to availability, whether certain entities could get insurance. Medical liability was one of them. And from that point forward, the pendulum did, to a degree, swing back. We saw tort reform enacted. We saw carriers perhaps change their underwriting practices. We saw alternative entities emerge, like risk pools, physician-owned mutual companies. And, my own view is that perhaps we are swinging back somewhat, at least, to that paradigm that we saw in the late 80s. So anyway, one of the things that we're...
The other thing, I just want to add one more thing to that, is that we've seen some of these really big verdicts that have gotten a lot of press that have either been against defendants that have no insurance or have a very small amount of insurance. Oftentimes, if they have no insurance, there's been a default of some sort, and this is really a trial that's an assessment of damages. Like, they haven't set it up that way. And of course, in the press, it's not made clear that there was essentially no defense put on and that no one's really expecting this. Like, there was a drunk driving death of a grandmother and granddaughter
in the Texas case, yep.
In Texas, that was against the bar, and I believe the bar had no insurance.
That's
and got wasn't it a multi-billion-dollar verdict?
$3 billion verdict, I think.
Yeah. And the press was reporting that the family had done it just to basically get information out there about, what was happening. But of course, those numbers impact on so many other things, and the fact that those amounts are never being paid, and in that case, no one even expected them to be paid, doesn't get the press.
Right, and great transition to the next slide. One of the things that we're often asked, these things do get, reversed, or they're settled in an amount less than the verdict that's published. And the answer to that is, yes, that's true. There are caps. Defendant will initiate an appeal, most often with a legitimate basis. But the reality is the damage is being done once that initial verdict is published, and it's something that law firms are using very aggressively in their marketing materials. On the right there is the website from a big plaintiff's firm in East Texas, touting the $730 million verdict he obtained in a road wreck case. Reality of it is, behind the scenes, that case was settled for less than 10% of that amount, but nevertheless, that's put out there in from websites used in advertising, which is another thing that we haven't really talked about directly in this presentation, but there's no question that attorney advertising is driving a lot of the social inflation. I'm sure many of you drive down the interstate and you'll see a number of these billboards. If you've been hit, call Neil Flitt, John Boy, Strong Arm of the Arm, any one of these personalities that are being developed and used in marketing materials. So this is something that has been and continues to be a problem. And, really, just to take you kind of in microcosm the way a particular case might work, this is actually based on an actual case. Tragic set of circumstances, wide load tractor trailer with a pilot and trail vehicle going over a bridge in a rural area, 10:30 on a Sunday morning. Plaintiff's decedent was coming in the opposite lane on this 2-lane road. It just finished teaching Sunday school. Some allegation with some basis that the pilot car didn't do enough to make sure that there was enough room for the car to get by. Plaintiff's decedent struck the tractor trailer, was killed instantly. So what happened in the case, though, was the firm went ahead and settled out with the target defendant, in other words, the operator of the tractor trailer, got the expert, the really good lawyer out of the case, and then proceeded to trial against the pilot car and the rear guard defendant. So what happened there was that a significant verdict was generated, and that's not, the case is ultimately going to be settled, but not at the amount that was originally published. So these things do take place with regularity. The one thing that I wanted to mention to you too is that these cases, huge amount of effort is being spent as far as building damage models, and there's a concept called anchoring that we'll talk about a little bit more in this presentation, but it's something that really the defense bar is learning how to deal with, but it is something that is in large measure driving up these verdicts. And then sort of the new math, I wasn't spend a lot of time talking about this, but if you're a plaintiff's firm and you have a significant increased chance of obtaining a large verdict, you have much more incentive to try that case than you might in the past. And that's certainly something that we're seeing. We're starting to see evidence of plaintiffs being more willing to take these cases to trial, to spend more and make more of an investment in working the case up and really make an attempt to swing for the fence. So anyway, so that's some of the things we're seeing. The next bucket, litigation, legal risks. And Laura, by all means, feel free to chime in at any point. Third-party bad faith is always a concern for an insurance carrier. One of the things that, certainly is always a concern, or many times is a concern for a reinsurer. You certainly don't want to see a verdict in excess of policy limits. And if opportunity to settle a case within the policy limit exists, purpose of the carrier, assuming that the liability is less than favorable, purpose would be obviously to settle the case.
Well, and I think the other thing is that the carriers need to be looking at cases for nuclear potential early on. They need to be, clearly there are certain types of claims that have historically and nationally been more likely to fall into this. Like trucking is definitely a big one. And like we talked about, medical malpractice. But the other thing is, who are the parties? How is the jury going to feel about, say, the elderly couple in the Georgia case with the truck tires that got several billion? And that these are situations that carriers need to be careful not to be penny wise and pound foolish. It's worth putting in the effort at the beginning of the case, spending the money on making sure that you've got really good counsel in place and that they're able to do what they need to do. Consider bringing in experts to help with the depositions of the defendant, for example. A lot of those can make or break the trial long before you ever get to trial. So those are situations where the carrier can protect itself both from a bad faith claim, but also from even if it's only partially covered, very large verdict. In the individual case that they'd be paying the verdict potentially, as well as the impact that verdict may have on other verdicts down the line or across the country.
Yep, a great point. And these other points we're going to talk about in subsequent slides. The reptile theory, that's a big deal. Talk about that in a minute. This next slide, one of the things that, is contributing to social inflation too is what are known as, really weak jury charges. This is an example of what we have here in Georgia. And the concern here, obviously, is that really not a whole lot of guidance, at least based on what's shown here, as to, how a jury is really supposed to evaluate things like pain and suffering, how they're supposed to quantify, both past pain and suffering and future pain and suffering. And, is there an opportunity for us to perhaps strengthen those instructions to give jurors better direction and guidance as how to evaluate elements of damage? Laura, do you have any thoughts about that?
I'm sorry, I missed the last of that, Tim.
About the weak jury charges.
Yeah, it's the reason pain and suffering is the area where we see the assignment of most of these is because it's squishy. And having any sort of guidance that provides some structure to that for the jury is helpful. And, the states vary on this enormously, and there's a lot of leeway to judges for the most part in what can be done. Again, it may also be, it definitely be impacted by whether plaintiff's counsel can, in their closing, request a number. A bunch of states allow that. And if they suggest that the plaintiff had, $300 million in damages, they probably start out with that in the opening and they work through the whole case. One of the ways that defense counsel is addressing that is by addressing the numbers from the beginning and having an alternative number so that the only number out there isn't the plaintiff's number, because it's hard to compare, a big number from one side and oh no, that's too big a number. And jury charges can be part of that, but most of that really goes to what the law is in the jurisdiction on how much plaintiffs can do. Also, frankly, it may be impacted by whether your judges are elected or not. And if the judges are elected, what the electorate might think of some of these different issues and whether the judge is keeping that in mind if it's going to be a case that hits the press.
Yep. All great points. We won't spend a lot of time talking about this, but the reptile theory, it's been around a while. It's something that, we believe is prevalent in a lot of these nuclear verdicts, originated by this guy named Don Keenan. And really, it's a theory in which you're basically crafting a case in such a way that it's appealing to what is known as the juror's reptile brain. In other words, that part of your brain where you focus on survival and perhaps to a degree suspend rational thought. And you do so by creating a paradigm of what are known as safety rules and basically pointing it out in such a way that defendant violated these rules, that and because the defendant violated these rules, your safety and the safety of the general public is at risk.
Right. It's putting the juror in the position of the plaintiff, yep, which as a general concept is not supposed to be allowed in the courts. It's supposed to be about the plaintiff and what their injury was and what happened or didn't happen with regard to the plaintiff. But there's been little limitation by the courts on the use of this. We're starting to see a little bit of it. I was involved in an amicus brief here in Massachusetts that addressed it, but unfortunately the court didn't pick it up very much. They had a couple lines that indicated that some of these golden rule issues and safety parameters were not within the scope that should be before the jury, but not much to work with. And that pretty much has been true across the country. There's very little that seems to be addressing this. So it's really up to defense counsel to address and neutralize these issues as they move forward with the cases. And it starts long before trial. Certainly it's happening at trial, but it happens before then as well to be successful to do it.
Yeah, absolutely. And then the one thing to just sort of pick up on, I think what Laura talked about earlier, fundamental to this reptile theory is this concept of anchoring, that you're anchoring, in other words, putting in the minds of the jurors, a big number as far as compensation goes. Now, there are ways on the defense side to combat that, but that is a key component. And that case that we had talked about a few slides back, the plaintiff was putting large amounts in the juror's mind relative to what the survivors of the decedent were owed, notwithstanding the fact they were adults and living productive lives. So this slide just really talks about how the reptile theory sort of flips the traditional liability script and, posits the case in terms of these safety rules and really, taking, for example, a trucking case that, the trucking company has duty to, make sure that every driver does everything possible to avoid an accident, which really, for all practical purposes, is impossible. But again, establishing violation of rules, establishing this threat to the juror's survival, and the notion of because of this anchoring, you will send a message to the community at large that this defendant's conduct / behavior can't be tolerated. That, in a nutshell, probably at the risk of oversimplifying, is the reptile theory. There are many ways on the defense side to combat it, but we still see a number of these verdicts having reptile theory in some manner or fashion being used. So, real quick, third-party litigation financing. This is a relatively new phenomenon. We've seen it in the United States in the personal injury arena really in the last 5 years. It's a $5 billion market in 2020. Swiss Re in January of 2022 put out a very informative study on the impact of litigation financing on the insurance industry and basically society at large. They document, and others have documented, that really it is contributing to social inflation. It's making cases more difficult to resolve. It's causing them to resolve at higher amounts. And there may be some ethical conflicts that are being created here that we'll talk about in a minute. So you have these funders / financiers involved with these cases and really able to generate some pretty significant rates of return. This was from something I picked up from an entity called Morning Investments, talking about the average internal rate of return for a personal injury case for a litigation financer. Pretty significant amounts here. A personal injury, 32, almost 33% rate of return. From an investor standpoint, that's pretty significant. So we have reason to believe that, litigation financing is involved in a growing number of these significant bodily injury cases, that there are firms that are targeting certain lines of business, certain categories of claims, and it's something that we as an industry, I think, are going to have to deal with going forward.
Well, and it has a big impact in a lot of different ways. There are cases that law firms couldn't possibly front the money for the required, expertise to move cases forward that they're able to do with these third-party financiers. It also throws a whole nother party into the decision-making process on settling a case, for example, or going to trial. And there are a lot of ethical concerns as to whether the lawyers and the client, are impacted as in ways that they shouldn't be by the third-party financer. The other thing is that it's, and we see this list here, but it's mostly unknown to other parties.
Yep.
And that, I think, is the area that we have the most chance of making an impact on this financing. But it's become pretty mainstream. There are now a lot of the traditional investment type of vehicles that are getting into this. It's not just a very small niche market for only a few investors. So I think we're going to see more of it. And we as an industry need to support disclosure rules so that people are aware of what's going on. And for the most part, I think it's allowed. I guess there are a few states that it is not, based on this graph. And, maybe we'll have some more changes in that as well. Either way, could be more allow it than currently do too. So
great points. Largely it's an unregulated industry, and really, with respect to regulation, really, two forms really. Should the disclosure be made to a jury that there's an existence of a third-party litigation funder behind the scenes? I would argue yes. Many others would too. But then really too, from a consumer protection standpoint, should there be some limitations placed on the percentage that a litigation financer might recover from a verdict or settlement? That's what happens obviously with consumer loans. There's some, coalescing of the industry. Groups such as the APCIA are trying to work in that area, but we're really, as far as regulating this, on the first steps of what will likely be a very, very long road to take place over a number of years.
Yeah.
We've kind of touched on,
there.
Yeah, pardon me?
No quick fixes.
No quick fixes, that's right.
Yeah.
Yeah, and more just to touch on some of this, but you've got another entity at the table, so to speak. Interfering with case strategy execution. Really is the lawyer who is involved with the funder really sort of in a conflict of interest in the sense that what may be in the interest of the funder might not necessarily be in the interest of the client. Might be, for example, in the client's best interest to settle the case earlier rather than later. Do we have ethical issues of the ethical issues rather than financier dictating discovery, retention of experts, that type of thing?
I also wonder how sort of the math comes out on these. We know that the very large verdicts are generally not paid in full. So some portion of that is paid, but the expenses on these tend to be very high because that's what the third-party litigation financing, what the benefit of having them is to be able to get really good experts and those sorts of things. But those usually come off the top before the plaintiff gets paid. So, I question whether this benefits the individuals that are, actually the injured parties. And second, whether they understand when they're agreeing to this, how that math is going to work in the end. Which are all things that for the most part, we never hear about. Those are, unless there's litigation over the litigation, those are not publicly available information. Really, it's a big issue, and it's something that, as we're talking about, we're going to have to wrestle with in the years ahead. One of the things that, we're starting to see happen in states is that you have these financing companies actually taking ownership positions in law firms. This was an article out of Bloomberg Law, late 2021, where in Arizona you're able to do this. And this is something that might be attractive to law firms going forward. So as I say, as we're saying, it's a very, very big issue. I want to talk a little bit about a subset of litigation funding called medical funding. This tends to be more of an issue in certain parts of the country than others. Metro Atlanta, where I'm talking to you from right now, it's a really, really big deal where you have medical funding companies out there basically taking on, in these cases, funding expenses, minor expenses for healthcare providers in exchange for the ability to blackboard large specials at trial, and basically recovering much greater amounts than they otherwise would be entitled to. These are actually firms that are operating here in Metro Atlanta and countrywide doing this. And it is something that, as I say, we're seeing more and more of. Interestingly enough, this was an article that came out of Law 360, where you had a pain clinic in Dallas, Texas, that was basically operating as a medical funder. They were essentially working with these attorneys, doing the treatment, and then with the hope that they would be recovering a large amount of money when these cases were settled and or went to verdict. This article talks about there being a dispute between the law firm and the pain clinic about who is owed what. So, this litigation is taking place to a degree as well. So you have litigation, third-party litigation financing. You also have this medical funding going on, and it's all going into the mix, so to speak, as far as what's driving social inflation. One of the other boxes at the outset of this presentation, medical cost inflation. This is something that we have seen more and more of. Doctors becoming entrepreneurs, taking cases on under a letter of protection. In other words, reserving the right to basically have a lien against any settlement or verdict down the road. We certainly have seen issues of excessive, unnecessary, and expensive and or unreasonable medical treatment. There's some suggestion that if you have a third-party litigation financer behind the scenes, that treatment might be
utilized in such a way to drive up damages, to drive up economic damages. Certainly some of that happening. The whole issue of medical expenses being incurred versus paid. In some states, you're able to submit the amount incurred. In others, you're limited to the amount that's actually paid. As you probably all know as consumers, there's oftentimes a big difference between what's actually incurred versus what is actually paid. The one thing, too, from an macroeconomic inflationary standpoint, a big component is healthcare. I just was reading an article the other day that medical costs basically make up 16% of the overall economy in the United States. So and as they go up, it's sort of a big chunk. So.
Well, and what this is sort of circular from what we were talking before about how medical malpractice verdicts are up. So yes. The insurance is more expensive because there are more bigger claims being paid. And so that's just adding to, all of these other factors that are making medical expenses higher than they have been in the past.
Absolutely. And related to that, one of the things that you have in a catastrophic injury case is the need for what is, ongoing medical care. Sometimes it's 24/7 medical care in the case of a catastrophically injured plaintiff. Well, to provide that care, you have to staff, and you have to bring in LPNs, you need to bring in nurses, and it costs more to retain that type of staff to engage, to account for medical treatment necessary for the lifetime of an injured plaintiff. Those costs are going up. We're starting to feel those now. We're starting to see evidence of life care plans. In other words, a projection the plaintiff submits to a jury as to what future health care costs might be, being increased by as much as 20 to 30%. We're living in an inflationary environment right now. We don't know to what extent it's going to stabilize in 2023, but certainly now it's much different than it was pre-pandemic. And one of the things that happens is because of increased interest rates, economic projections tend to have more of an inflated value over time. And the way I would look at it is what I have written in parentheses here. When we have higher interest rates, that means that the present value of payouts in the future are going to be much lower. So values themselves are going to be much bigger down the road. I butchered that explanation. But anyway, just to give you a case study of what we're talking about, let's say that you've got a catastrophically injured plaintiff, let's say in a medical malpractice case, and that person requires 24/7 care from a licensed practical nurse or LPN. In 2018, pre-pandemic, you could engage an LPN for basically $45 per hour for lifetime, for a total life care plan of $54 million. Well, 2023, that LPN to provide that 24/7 care is now costing you $65 an hour, and that life care plan now checks in at $74 million. So these are inflationary pressures that really come to bear on these catastrophic injury cases, and to a lesser degree, other cases that involve some form of bodily injury. So, and as I say, given the inflationary environment we're living in now, this is something that I don't think is going to go away any time soon. Real quick about societal shifts. I think, as we said at the outset of this talk, society now in 2023 is certainly different than it was pre-pandemic, certainly 20 years ago. One of the things that some commentators have talked about is what is known as sort of the decline in personal responsibility. One of the things that you would, of course, argue in a liability case is, contributory negligence on the part of the plaintiff. Hey, the plaintiff either caused directly or contributed his or her own injuries by her own actions. There's some evidence, some suggestion that juries are really sort of discounting that and instead more inclined to pin liability on the part of the defendant. No secret there's a huge increased distrust of corporations, institutional defendants, the rise in wealth disparity, we've talked about that. But, the other thing, too, that's gone on in our society, commentators are the author of the book Big Sword and Bowling Alone. We are not the community that we were. We're not the general community that we were 20 to 30 years ago. We have sorted into basically different economic groups, living with different similar people situated economically, demographically. Might that be playing a role in how we're viewing, how jurors are reviewing cases? And then the other thing too, risk aversion, rule compliance, generationally, and partly because of the pandemic, we have different views as far as what amount of risk we're willing to take. Are certain segments in society more prone to be more concerned about safety than other generations? Are certain parts of society more concerned about compliance with rules? These sort of things all sort of get thrown into the mix and are something that, are different now than they were 20 years ago. Could probably do a whole seminar on the impact of social media, what that has meant and what that's continuing to mean to our society, and really look at how fragmented we are politically, how we are so polarized in society on a variety of issues. This is something that's obviously spilled over into social inflation and these social verdicts that we're seeing.
And these are also things to keep in mind as you're looking at your jury pool, as you're looking at the venue that you're in and whether you have any ability to change that venue. All of these issues are ones that should be thought about at the beginning, because you can get a handle on what your anticipated jury pool would be for a trial in the jurisdiction that you're in. And you know what the basic facts are of the claim. And is that going to be something that is going to resonate, really well, not so well, with the jury you would anticipate in that. And I particularly think with that distrust of corporations, that we're looking at certain generations that seem to have much more distrust of corporations. The older generations have more trust of corporations generally. Younger generations have much less. And those are things that if you have a corporate defendant, you need to make sure, whether it's you as the insurer or your defense counsel, that you're putting in huge prep time for the deponents that are either the one you choose under a Rule 30b-6 deposition, or if they're individually named in some manner. You want to make sure that they put a good face on that defendant as much as you possibly can, and anything that's said in the deposition has the potential to come out when that person is on the stand at trial. So don't wait until trial prep to look at these issues. Do it when you're looking at depositions and when you're looking at the case and figuring out, okay, who's going to get deposed here, and who do we want to be the face of the corporation, and how do we make them the most acceptable to the jury that we can in the circumstances. Especially if it might be a case you want to settle, but the plaintiff won't settle it. So you can't always assume you can settle it, because if this is one of those cases that one of the lawyers wants on a billboard, they may not be willing to discuss a settlement, or at least in numbers that the insurer is willing to discuss.
Absolutely. And then really, these emerging risks and exposures that we're seeing, public nuisance theory, certainly that's been a theory that's being advanced in opioid litigation with varying degrees of success. It's something that we're seeing now, these climate change litigation suits that have been brought against the carbon majors by several states' attorney general. Theory of recovery that is to varying degrees of success, has varying degrees of success. Defamation, I'm sure many of you followed the Amber Heard Johnny Depp trial.
There's also the Sarah Palin suit against the New York Times.
Yes, excellent point. Those are seeing more and more of those. Some have suggested that social media, people being more sensitive to, their social media presence, what may be said about them, what may be defamatory, that there might be more of an inclination for lawsuits in that area. The other thing that there's been some suggestion of, and Laura, I know, has handled a number of these cases, homeowner versus homeowner, dispute over an easement or property being used. Those are tough cases to handle, aren't they, Laura?
Yeah, they're very personal to the individuals who, especially if they're continuing to live next door to each other. And there are oftentimes limited coverage for those, because a lot of times it has to do with the property line, for example, which is not something that will be covered under a homeowner's policy. On the other hand, I can remember one of the cases I handled had to do with the fence and where the property line was. And then there was destruction of plants that was along where the fence were. The only thing that was covered in the case was the plants. But to get the case settled required some sort of a restraining order and who could go where with regard to the fence, and it was awful. And the defense costs were significantly higher than the plants. So these are cases that can be messy, and that probably your juror, every one of them, could imagine themselves in some, on one side of it. So depending on how the facts of the case are, that's something to keep in mind, because if somebody has had an issue with their neighbor ever, or their mother did, or their cousin, or their friend, or whatever, they may be pretty willing to throw a lot of money on it because they understand the pain. So
absolutely. Yeah, so, and it's interesting. I mean, I've read an article in the Wall Street Journal about these homeowner versus homeowner suits, how we're seeing more and more of them. Emerging risk, PFAS, the forever chemicals that are basically everywhere. What is that going to mean from a health standpoint? The health effects are in large measure unknown. There's some real concern about that, and real scrutiny on the part of federal and state regulators, how do we remediate PFAS from the water supply, and who pays for it? All issues that are going to unfold over the next couple of years. Talc, another one that, you probably have read about, but then also other ones on the horizon that might not be as visible to everybody, such as microplastics, these small, very, very small pieces of plastic that never completely break down. They've been found on all 7 continents. They've been found in the atmosphere, the air. What does that mean for us? Are there adverse health consequences associated with that? These sorts of things are being on there every day, and it's the world we live in. So, really post-COVID trial environment, just a couple words to say about that. Courts are working through, the backlog that came from the pandemic, big pressure on the part of the defense bar to work up these cases, taking into account, obviously, these changes that have occurred because of inflationary pressures, having to update life care plans, re-engage experts, and so on. So, it's going to take a while for that to work through. But then also, what can we do as, really an industry, a defense bar to defend these cases? That graphic there is from a guy named Bob Tyson. He's a San Diego-based lawyer. Very colorful guy, but he's written a book called Nuclear Verdicts, and he talks about, along with several other attorneys, really moving away from strictly liability-focused arguments and instead talking about the things that the plaintiff is capable of doing, the things that can be provided from a damage standpoint that will enhance or at least remedy that person's quality of life. And really, and another side, parenthetically, really attacking or defending damages to the degree that properly was and talked about 20 to 30 years ago. The other thing that I would mention, or we would mention to you too, is this blurring of jurisdictional distinctions. Anybody that is involved with a potentially big case, don't assume that it can't happen to you, because it can. And as I say, we've seen these things pop up in areas that I never thought we'd seen before. $30 million road wreck settlements here in rural Georgia. It's something that we simply wouldn't have thought of as recently as 5 years ago. As I say, to this damage point too, using economic and rehabilitation experts effectively, demonstrating to the jury what other sources might be available to compensate a plaintiff for his or her injuries.
But again, there are limitations on these by court rules and judges.
Good point.
So those are things that, you may or may not be able to do some of those things in your jurisdiction. Certainly the collateral source rule is alive and well, and letting the jury know that they had health insurance. Anymore, I think one can't assume that everyone has health insurance. So,
great point. Absolutely. And then the other thing too, collaborate with defense counsel as an industry. We're starting to see, boot camps being formed, where we have lawyers getting together with carriers to talk about how to better defend. Trucking case is an example. There's an outfit here in Atlanta called American Legal Connections, which is just such an effort on the med-mal side, getting carriers and feed lawyers together to really talk about these issues, kick around what works, talk about things that maybe didn't work on a prior case and what you might do to correct it going forward. And then also, to the extent we need to talk about litigation financing, the damage it's causing, and then, really step up efforts from a regulatory standpoint. So we are almost at the end of our hour.
I know, we haven't had any questions.
I know it. And we like questions. We love questions.